Thank you, everybody, for coming. We're starting a few minutes late, but we're all here, and we're happy to see you. In fact, I'm very happy to see such a big crowd, given the interesting competing sessions that we have at this time. So this is the panel on costs and benefits, or benefits and costs, if you're an economist. I'm Susan Dudley, and I'll just kick things off. Congress has made thousands of delegations of regulatory authority to scores of administrative agencies with widely varying standards for making those decisions and no regular process for bringing coherence to the whole. So the economics profession has long proffered benefit cost analysis, or BCA, and that's how you're going to hear me referring to it, even though you might hear the lawyers on the panel calling it cost-benefit analysis. And we can talk about that if you care to know why economists refer to it differently than lawyers. So economists have proffered it as the best tool for ensuring that regulatory decisions that wield that delegated authority responsibly and wisely. So the idea behind it is that agencies should balance the benefits and costs of alternative approaches, evaluate them of alternative approaches, and choose the approach that maximizes the excess of benefits over the costs, or the net benefits. And presidents from both parties have, for over 4 decades, endorsed that and as the preferred way to do it, and required agencies to submit their regulations, actually this is only for 3 decades, to the Office of Management and Budget, the Office of Information and Regulatory Affairs, or OIRA. In fact, Executive Order 12866, which President Clinton signed in 1993, was affirmed by both George W. Bush and by Barack Obama, who have widely differing views on what regulatory policy should be, but they all agreed on that as the paradigm. Yet it's not consistently applied, and in part that's because authorizing legislation often either is silent on whether agencies should do that, or is written so that it prohibits a balancing of benefits and costs. Independent agencies' compliance, executive orders don't apply to the independent regulatory agencies, such as a lot of the financial regulatory agencies. And compliance with the executive orders is not something that courts can review. Executive orders always say this is not judicially reviewable. So Congress is considering bills now that would address this in various ways, by codifying the executive order requirements, making sure that they apply more broadly, and asking that they be judicially reviewable. And Senators Portman, Warner, and Collins are introducing a bill. It's the Independent Agency Regulatory Analysis Act that would subject those independent agencies, like some of the financial regulatory agencies that I think we're going to hear more about from our panelists today. But the question still remains, is benefit cost analysis a silver bullet? And if not, what procedural or analytical changes might improve its usefulness as a policy development tool, and I guess a policy evaluation tool? So we have a terrific panel of legal and policy experts that will explore those questions and examine the appropriate role for Congress, the legislature, and the executive branch, the proper scope of BCA, and when analysis should be conducted and by whom. So before I introduce them, I'll introduce myself. I'm Susan Dudley. I'm the director of the George Washington University Regulatory Studies Center and a distinguished professor of practice in the Trachtenberg School of Public Policy and Public Administration. I have achieved the distinguished status despite the fact that I cover all the grays in my hair. I served as administrator of the Office of Information and Regulatory Affairs from 2007 to 2009. And I'm going to put in a plug here. I am the vice president of the Society for Benefit Cost Analysis. Now, you may not have known there was such a thing, but I'm happy to tell you more about it. We have a journal, and I welcome you all to come to our meetings and participate. All right, so the panel that we have here, it's a panel of underachievers. As I was looking at their bios, I'm going to give you abbreviated bios for all of them, but I did notice that all the lawyers were editors-in-chief of their law reviews when they were in law school. And I'll introduce them alphabetically, although we're going to go in a slightly different order. Boyd & Gray, C. Boyd & Gray, is the founding partner of Boyd & Gray & Associates and a leading expert on regulation. He worked in the White House for 12 years, first as counsel to the vice president during the Reagan administration, where he was responsible for President Reagan's executive order on regulatory oversight and benefit cost analysis, and he was counsel to the Presidential Task Force on Regulatory Relief. He also served as White House counsel to President George H.W. Bush and ambassador to the European Union during the George W. Bush administration. And between these appointments, he practiced law for 25 years at Wilmer, Cutler, and Pickering. Next, I'm going to do this in the order that we'll hear from them. Next, we're actually going to hear from Dick Morgenstern, who's a senior fellow at Resources for the Future, and he's our sole economist on the panel, but equally distinguished, as you'll see. His research focuses on the economic analysis of environmental issues with an emphasis on costs, benefits, evaluation, and the design of environmental policies, especially economic incentives. Prior to joining RFF, he held senior positions at the State Department, where he participated in the negotiations for the Kyoto Protocol, and at the Environmental Protection Agency, where he served for 12 years, acting as Deputy Administrator, Assistant Administrator for Policy, Planning, and Evaluation, and serving as Director of the Office of Policy Analysis. And then we'll hear from Michael Livermore, who is an Associate Professor of Law at University of Virginia. He's an expert in administrative law, environmental law, cost-benefit analysis. I'm reading from his bio, that's why the order is wrong. And executive review of agency decision-making. Prior to joining the faculty there, he spent 5 years as the founding executive director of the Institute for Policy Integrity at NYU School of Law. He's published numerous books, chapters, and articles on administrative law and BCA, with a special focus on the role of interest groups and public choice dynamics in shaping the application and methodology of cost-benefit analysis. And we'll hear a little bit about that from him today. And then finally, we'll hear from Gene Scalia, who is a partner in the Washington office of Gibson, Dunn & Crutcher, where he's co-chairman of the firm's labor and environmental practice group. He previously served as solicitor of the U.S. Department of Labor, and that's the department's principal legal officer with responsibility for all the Labor Department's litigation. He's also handled a range of appellate and regulatory matters, with particular concentration in litigation involving federal administrative rulemaking, and he will also share some of his insights from that with us. So without further ado, I will turn things over to Ambassador Gray.
So thank you for this opportunity and the introduction. Cost-benefit analysis started formally back in 1981 when Reagan got elected, set up the Task Force on Regulatory Relief, and approved it, Executive Order 12291, which became 12866 with that much change. It's been basically the same throughout the years since its adoption, which requires cost-benefit analysis for any major rule. And it's subject to at least two serious vulnerabilities. One is it's not, as Susan pointed out, reviewable in the courts. The president can't create jurisdiction for executive orders. He might talk like he does, but he can't. And as a result, there's a lot of gaming that goes on and a lot of games played with inside the executive branch. And those rules and those games are, I think, fairly well understood. I want to cover them a little bit, but then I want to go further and say, you know, what would happen if these judicial review provisions were extended to all rules, not just independent agency rules, but all executive branch agency rules where a cost-benefit requirement is not already in the statute, which in some cases it is. and see what that would do. And I think that Gene Scalia is going to go through what help that adds, what problems it causes, it solves. And so I'm going to leave that discussion to him. He's been involved in some of the leading cases and knows as much or more than perhaps anybody in the city. And I want to end with a discussion of what is really the source of all the difficulty, principal source, which is the large amount of delegation to regulatory agencies. The way cost-benefit can be gamed internally inside the executive branch, the typical way to do it is to claim co-benefits from related programs that are going to happen anyway. In some cases, they're claiming co-benefits from reductions that are below a requirement that already exists, and there isn't necessarily a linear response ratio all the way down to zero. In the Section 111D proceeding, for example, which is pending now, and we're going to hear about it very soon from the court, the Supreme Court, the case is claiming most of its benefits from PM reduction. It happens to coincide along with the other reduction of the CO2 reductions that are the target of 111D. And these CO2 reductions, these fine particle reductions are are lower than the standard that the government has set for that pollutant. And the government has refused to go lower because they say there's no evidence of harm. So if there's no evidence of harm to excuse or to support a lower standard, how can you count those benefits below that standard as co-benefits of equal stature? And furthermore, of course, Section 111D prohibits the agency under that section from using it to regulate a substance which is already subject to a national standard, which the largest co-benefit is already subject to a national standard. So if the agency can't regulate PM, how can it count PM, therefore, as a co-benefit? Really a lot of difficulties, and counting the global benefits of the CO2 reductions, the global warming reductions, claiming the global benefits of the reductions as benefits to Americans is gilding the lily a bit. So we have those difficulties, and the only way to straighten them out, ultimately, I think, is to get a new president, and in the long term, to have it be subject to judicial review in the courts. The question of deference and using cost-benefit as a constraint on the agency has been kicked around before, and it's a highly potent weapon. It has not yet obviously been adopted because it's not available for most agencies and most laws. But the law does say, the case law does say, that even if cost-benefit per se doesn't apply, an agency must be found to be regulating a significant risk. Not a de minimis risk, but a significant risk. And a lot of risks that are being regulated are not significant. Some of the benefits that are touted, for example, that were touted last time for a very, very tight ozone standard were described, which was pulled back, were described as highly speculative. And I do not believe that anyone can argue that a highly speculative benefit can be considered a significant policy benefit, be an answer to a significant risk. This has sort of been missed in the fog of war, this requirement that there be a significant risk addressed. And as Judge Williams said in one case, I think the Michigan case, cross-state pollution case, he said, citing Breyer and others at NYU Law School, Professor Stewart, if you have a significance requirement, how can you possibly determine significance without looking at cost? So even if you don't have a cost-benefit formal requirement, you do have in the law to protect against over-delegation, to put up a halt to some, to put up at least the floor on agency runaway action, some sort of limiting principle. That principle can stop a lot of damage from being done. And the advantage of this is that when you get into a case where you say, oh, the delegation is too broad and there needs to be some constraint, and the constraint should be showing that what you're doing is addressing a significant risk, that decision is not for the agency to make or to interpret subject to Chevron deference. That's a decision, which the Supreme Court has made clear, is a decision the court makes. So a significant risk, questions of delegation, trump deference. And deference has become very popular now as a source of huge difficulty, rightfully so, but I want to point out that it's not too difficult to remedy it if you understand what the rules are, that you have to have a significant risk, otherwise you're getting into non-delegation territory, and when the court makes that decision, it's making it on its own. It does not have to defer. It owes no deference to the agency interpretation whatsoever. So I hope people will keep that in mind in this panel discussion as it unfolds, and as Scalia tells us about his cases where, thanks to an internal provision of the statute, as in the Business Roundtable SEC case, there was a cost-benefit requirement. It did go to court. The argument against it has always been, oh, it's going to clog the courts. The liberals make it's going to clog the courts, and oh my gosh, wring your hands, we'll never get any regs out. Well, the D.C. Circuit has the lowest caseload of any appellate court in America, and it can certainly handle it.
Okay, next we'll hear from Dr. Richard Morgenstern from Resources for the Future.
Thank you, Susan, and thank you for the invitation. It is a pleasure to be here, and it's a pleasure to follow my friend, Boyden Gray, who is also a member of the RFF board, I would point out. So I am going to try to touch on, I'm going to make 4 points. 2 of them really briefly, and 2 of them a little longer. The first point is that while, as Boyden said, the executive orders are widely accepted, there still are major differences that you can actually see across party lines. And I'm going to talk about what those are. I'm going to come back to that. The second point is that there are ways to improve RIAs. There's no question about it. And Boyden mentioned 2 points, which is the potential for double counting and the consideration of speculative benefits. There are others, but I will try to address both of those. The 2 points I'm just going to hurriedly say, because Susan and I talked about it earlier, and she thinks I have something to, some value in what I might say. 1 point is that how do you deal with jobs issues, jobs and regulation? And the short answer in that, it's a long story, but the short answer is the focus heretofore has been on what's going on within the firm or within the industry as a result of regulation. And there's a lot of complex factors going on. There are demand effects, cost effects, factor substitution effects. All that's true. Okay, very hard to measure, but it's true. It's also true that there are impacts outside of the firm and outside of the industry. Okay, and if you were going to really think about this problem rigorously, you would think about it in a general equilibrium framework, because that's really what the story is. A regulation changes a lot of things in the firm, in the industry, and then causes secondary effects. No one's really mastered all that yet quantitatively. The models are pretty far from doing that. So some people have advocated, well, there are these obvious welfare losses to people who do lose jobs in the industry. Let's count those, okay? And that's close to being quantifiable in a credible way, but it leaves out a lot of things, as I say, that are kind of beyond the boundaries of the initial firm. So my own judgment, which is just my opinion, is that these factors, to the best we can quantify them, should be included in the analyses, kind of as they are now. Now, you can critique the way they're done, but the notion of doing them is correct. You probably shouldn't try to put the welfare effects into the cost-benefit framework, because that's kind of pushing the envelope beyond where we are now. That's my one quick point. My other quick point is, how about retrospective analysis of regulation? Well, I'm doing that. I've done it for a while. I'm doing a lot of it now. And the question is it a good idea? Well, obviously, it's a no-brainer to do it, okay? The reason why there isn't more of it is it's actually quite tough to get the information, and it's really hard to do, and there's not much incentive for anyone to do it. The agencies don't really have an incentive to do it because it makes them look bad potentially. And outsiders, other than researchers who are, trying to, independent researchers, are some of them are going to get to this as I'm getting to it, but it's a struggle. And I know Boyden has said in other contexts that there should be an outside entity, maybe CBO, or maybe some outside research group. And I think that's the only way to do it, by some independent effort. I'm not quite sure which one, but it ought to be done, and it ought to be done independently. But that's the longer story. Okay, so let's come to my two big points. What are the differences that one can observe between Democrats and Republicans, and how would you ever measure that in any kind of serious way? Well, my colleague at RFF, Art Frost, who many of you know, who served at OMB for a long time, Art and I were kind of struggling over this issue, and we stumbled on a very simple notion. There is a document that you probably all know about called the Annual Report to Congress on the Benefits and Costs of Regulation that Susan was the leader of for a couple of years, okay? In fact, these reports have been issued by every OIRA administrator since 1997. And when we did our study, there were 15 of them that were out there through 2012 when we had the data. So we pretty carefully went through the text and looked for areas of emphasis and points they made, points they were silent on, or the emphases they put on it. We had a research assistant conduct sort of a content analysis of these 15 documents. And through all that, we deciphered 6 differences that I'm going to try to lay out for you quickly. Number one, there seems to be a difference between Democrats and Republicans on the oversight role of OMB. That's pretty clear. And, Republicans sort of embrace the trust but verify model, okay, whereas Democrats say, well, transparency is what you need, and we'll use the fact that we put a lot of information out there, and we'll trust people to do the right thing, and we'll trust the forces of open society to kind of rein in, despite the constraints that there are, rein in any excesses. That's one difference. A second difference is the emphasis on the monetization of benefits. Democrats want to monetize a lot of hard-to-grasp issues, ecological benefits being one. And, Republicans are more rigorous, if you want to say, or have a higher bar for saying what constitutes legitimate effort to monetize these things. And so Republicans seem happier to put these in the category of non-monetized or uncounted or, uncounted or non-quantified or not monetized benefits. And Democrats want to get them above the line. So that's a certain tension. A third tension is on costs, okay, and the scope of the costs considered. And what you see is that basically Democrats, consider a broad set of costs, but Republicans tend to put more emphasis on, for example, small business impacts. And that's a clear difference. And there's some other categories. Behavioral economics, Democrats like to use behavioral economics and like to put a lot of information out there. Republicans are a little more skeptical. Intergenerational benefits, Democrats seem to be happy to weight the preferences of future generations more than Republicans who want to impose a discount rate more comparable to one that would apply to other investments in our society. And finally, the broader economic impacts of regulation. And I would say that Democrats tend to focus on the positive link between regulation and overall well-being in society, and Republicans are focused more on the trade-offs in terms of lost jobs, things like that. So these are the 6 points that we gleaned from this. The overall point, which I perhaps should have made at the outset, is that there's a lot of agreement, okay? And these 6 points aren't meant to say that there's not a lot of agreement. I would say, and Art and I said in this paper, that the executive orders have introduced a framework and an approach that clearly is followed by both parties, at least up to some point. And these are the kind of differences that we teased out. How many minutes do I have?
3.
3. All right, this is going to be tough. Okay, so my last point that I wanted to make is I did a paper a couple years ago that actually reached out to the left, okay? And some of you may know who Lisa Heinzerling is, and this is before she became an assistant administrator at the EPA. She's a Georgetown law professor, and she was a co-author of a book which is called Priceless, okay? And it was a pretty heavy attack on benefit cost analysis. And my colleague, Winston Harrington, and I kind of said in some conversations with Lisa, look, maybe there's some middle ground here. Maybe we can find some area where, we could bring you on the boat, and maybe we could make this a little more attractive. And we came up with a number of topics. And let me try, I'm not going to go through all of them, but I'll mention a couple, because a couple of them relate to Boyden's points. One of them is that, a couple obvious points, that some of these RIAs, and we didn't do this based on philosophy. We did this based on actually studying specific RIAs. We had like work groups that studied RIAs, and we had debate, and it was not based on the theory. It was based on the practice, and we chose a number that. So a couple of points. One of them is that alternative options were really not considered in several of the RIAs that we looked at. They just picked an option and then kind of were basically justifying it as opposed to considering alternatives. A point that Boyden made about double counting, we labeled the same phenomenon with a different title, but it's kind of the same thing, which is the proper baseline, okay? And that you really need to have a transparent and credible baseline, and one that speaks to the relevant issues. And if you don't, there is certainly the potential for double counting. There are other problems as well. We also suggested that there be some kind of checklist that would be put forward for the key elements, not every element that's ever written down about what an RIA ought to be, but there ought to be some consensus on some minimal stuff, and that the agency ought to be obliged to say why they didn't include certain of those key elements in their RIA. And just blasting through it, as some of these RIAs do, it seems kind of meaningless. Let's see. We also talked about the topic we call relevance to agency decision-making. So some of these things devote a huge amount of effort to establishing precision over really small categories of issues. And one of them I remember had just an unbelievable amount of effort went to get a precise estimate on a pretty small category, when in fact huge categories were ignored, and they would just say, well, we don't know how to deal with this. And I think that's a legitimate claim that people make, that there ought to be some balance, there ought to be some more strategic consideration of what's going on in these things, and some of these RIAs clearly miss that. On the treatment of, to Boyden's point about speculative benefits, I think Lisa and Winston and I kind of agreed that there ought to be a quicker elevation of scientific consensus, a quicker move towards scientific consensus for new research. So what happens now is, some of this stuff just gets buried, it never comes in, and it's always called speculative. Well, okay, one reason it's speculative, it hasn't been adequately reviewed. And you ought to have an SAB in the case of EPA, but other agencies have NAS, whatever you want. There ought to be some procedure for taking these categories of benefits and pushing them more quickly, more strategically through the review process, so they actually, we can't stand up here and make judgments. We can't say, well, this is too speculative or not. There ought to be a group of scientists who make that judgment. And so that's, I think, the point. Okay, I'll stop there. Those are sort of my key points.
Maybe more in Q&A.
Yeah, there's more in Q&A.
Interesting. It's
Exactly.
fascinating.
Sure. Thanks.
Yeah, thank you very much, Dick. Okay, next we'll hear from Professor Michael Livermore.
Great. Well, thanks so much, and I appreciate the opportunity to be here, of course. So Dick's paper was wonderful, and I thought it did such a great job of kind of showing some of the systematic differences between the political parties on cost-benefit analysis methodologies, and of course showing that there's a lot of overlap and agreement. I mean, we're actually disagreeing along a really small portion of like all of ideological space, right? We've portioned out a really tiny piece of it, and we fight about it. And that's fine. With respect to some of the structural questions around executive review, there's actually less consistency with respect to the two parties. Many of the ideas that are floated that we'll talk about today, that are talked about in the broader public discourse on these issues, have been around for some time. We've actually been talking about more or less the same things for a generation. And preferences over these structural policies have a tendency to track the fate of the political parties, right? So the party that's in the White House tends to love executive power, and the party that's out of the White House tends to spend a lot of time talking about executive overreach. And we've just seen this as a cycle that has happened over the years. So I went through and I had actually dug up something that I found in another research project that I thought kind of speaks nicely to this kind of cycle of opinion over these structural questions. It's a piece by Justice Scalia, writing before he was Justice Scalia. He was an editor at Regulation magazine at the time. This is 1981, shortly after Ronald Reagan had been elected in office. And so he writes basically that these efforts to what he refers to enfeeble the executive, which the Republican Party, at least some portion of the Republican Party, embraced at the time, was a terrible idea because now they were in the White House and they needed to use the power that they had in order to vindicate their preferences and carry out what they saw to be an electoral mandate at the time. So he writes that Republicans in Congress seem perversely unaware that the accursed unelected officials downtown are now their unelected officials, presumably seeking to move things in their desired direction, and that every curtailment of desirable agency discretion obstructs, principally, departure from a democratic produced pro-regulatory status quo. Their attitude promises to do major harm to the drive for genuine regulatory reform. Okay, so that's the general principle. He goes through and identifies several policies. One is an amendment in Congress to undo deference to agencies, right? So to instruct courts to be less deferential. He says this is a terrible idea. It does not eliminate the authority, it merely transfers it to federal courts, which at the operative level will be dominated by liberal Democrats for their foreseeable future. So that's on agency discretion. He does another on an effort to beef up the rulemaking process, make it more difficult. He says, again, this isn't a good idea because it's going to make it difficult to change the status quo. He talks about the legislative veto, which is no longer really, it's not constitutional under Chadha, but we have something similar that gets floated in the REINS Act. And he basically says, again, in effect, you're going to lock in the status quo, you're going to make it more difficult to enact reforms. He talks about statutory requirements of cost-benefit analysis. Right? So is that a good idea? Should we have a statutory requirement of cost-benefit analysis? And so he says, this is again not a good idea, because a rule that merely undoes a pre-existing rule also has costs and benefits. Okay? So what you would be doing by enacting this statutory requirement and making it subject to judicial review is extant regulation will be accorded a sort of presumptive validity, and you're going to lock in that status quo. And so ultimately, all this stuff, when you kind of take it together, and this is a quote, executive enfeebling measures, such as those discussed above, do not specifically deter regulation. What they deter is change. And he goes on to say, regulatory reformers who do not recognize this fact will be scoring points for the other team. Okay, so that's Justice Scalia circa 1981. So how do we so now basically everyone's views about this stuff are flipped, right? So Republicans now hold the opposite views, Democrats now are in favor of executive reform. At the time, of course, in 1981, the Democrats were like, claw back executive power as much as possible. We don't want the White House to have influence. So, all right, so what do we do with this? So one question is this just the way it is? Is it always going to be that people will just cycle back and forth depending on whether they're in and out of the White House? Or can we try to abstract this out from our personal substantive preferences of the moment and to kind of think about this in some kind of general way? So here are what I think to be the more general questions. So one is, how responsive do we want agencies to be to elections? I mean, this is a question that we have faced in the country for hundreds of years, really. I mean, since there's been anything that looks like an executive state, which Jeremy Shaw says is basically since the time of the founding. And that's just a hard question, because on the one hand, our democracy, we think agencies ought to be responsive to elections, but when we lost the last election, we don't want it to be all that responsive to elections, and we might think that there's some professionalism or other consistency reasons that we want agencies to have some kind of similarity over time. If agencies aren't going to just be responsive to elections, then what do we want them to be responsive to? What are some of the options? Okay, thank you, Susan. Okay, well, what are the options? So one option that gets kicked around is, well, they should be responsive to the law. That's what they should do. We should just have agencies that are responsive to the law. Sounds nice. I mean, certainly to the extent that the law is clear and unambiguous and not vague, then obviously they ought to be responsive to the law. But I'm kind of a believer in what Jeremy Shaw refers to as which is a different kind of law, but the law of the conservation of agency discretion. Okay, it's almost like a principle of the state. And the idea is that, yes, you can write more detailed statutes, but all you do is kind of slosh around discretion. Maybe you move it from the rulemakers to the adjudicators. Maybe you move it from the adjudicators to the enforcers. Maybe you move it from one kind of statutory question to another kind of statutory question, from a legal question to a scientific question, from a scientific question to an economic question. But all you're doing is sloshing around discretion within administrative agencies rather than actually reducing the aggregate amount of discretion that exists within the executive. So if we accept that to be true, then just saying the law is what agencies should be responsive to isn't really providing us with any kind of adequate response. What we want to do is perhaps use law in order to structure agency discretion in ways that we think might lead to beneficial outcomes, but just the law itself is not going to be a final answer for us. Another option would be we want agencies to be responsive to professional norms. Some level, that's what we have with the cost-benefit analysis requirement. What we basically do is we say, agencies, you should do a cost-benefit analysis, and more or less what administrations from both political parties have done is kept their use of cost-benefit analysis within broadly acceptable norms within the economics profession. And so now there's going to be some space there, right? It's not like the economics profession agrees about everything. You get 10 economists in a room, you get 10,000 opinions about different things, right? But within that space, the parties are going to disagree, but they're going to keep it within that space. We're going to keep it within those professional norms. That's nice. That might be a good thing if you agree with the professional norms, right? So folks like Lisa Heinzelink, folks on the right who are more libertarian-oriented, do not agree with the professional norms, do not agree with, for example, that what government should be doing is maximizing aggregate welfare. Not everyone agrees with that proposition. Maybe we should be protecting individual liberty instead. So there's some disagreement even about whether the professional norms are right, and of course the professional norms don't provide us with the ultimate answers to a lot of questions. There's still a lot of value questions, behavioral economics. Should we be doing that? It's a technical question, it's also a value question. Should we be giving more or less weight to future generations? It's a technical question, kind of. There are technical elements to it, but there are also value elements as well. And then, there are questions about what kind of elections do we want agencies to be responsive to? Do we want them to be responsive to presidential, national elections, or more like congressional elections? This is an allocation of power between the branches, but it has a normative component to it. And, I tend to think presidential elections are more representative. There's more voters, but people can disagree about that. And if you think congressional elections are more representative or more democratic in some way, maybe agencies should be more responsive to Congress instead of the president. Okay, so the final issue that I want to address very quickly is about the role of OIRA in all of this. Do we like OIRA? Do we not like OIRA? Should we replace OIRA? Should we get rid of it? Should we replace it by some independent body? So my view is that the best way to think about what OIRA's role is to basically serve as a moderator, or a moderating influence, I should say, over executive discretion. Okay, so OIRA is a generalist agency, so it's less inclined to get captured by any specific interest group because there's lots of different interests that have business before OIRA. That includes just interest groups proper, and also ideologically charged activists within a party within a party base. Okay, and so OIRA is less likely to get captured by that. And I think if you look at administrations from both parties, you see that in Democratic administrations, OIRA tends to pull things a little bit to the right, and in Republican administration, OIRA tends to pull things a little bit to the left, ultimately ending up with a more moderate set of outcomes. And I think that's ultimately a good thing. I think that role can only function when OIRA is in the executive office of the president, and not as an independent reviewer, because my view is that an independent reviewer can't have that kind of political influence within the White House that is necessary in order to actually influence outcomes. If you actually take that body and put it outside the White House, unless you gave it a huge hammer, which I don't think that Congress will ever do, it's going to be less influential at actually influencing outcomes. So with that, I will end, and I look forward to the continued conversation.
Thank you very much, Michael. Okay, our final speaker will be Mr. Eugene Scalia.
Thank you. I want to thank Michael, I think we all should, for that reminder of what a wiser man Justice Scalia has become compared to his youthful days as an academic. I'm going to focus my remarks on a series of cases here in the District of Columbia concerning cost-benefit analyses as performed by financial regulatory agencies. There have been a series of decisions adverse to the SEC and the Commodity Futures Trading Commission. Those have been characterized by some commenters as establishing an impossibly high bar for cost-benefit analysis by regulatory agencies, and indeed some commenters have said that financial regulators are particularly challenged and unsuited to engage in cost-benefit analysis. So I disagree with both of those propositions, and indeed I believe these cases reflect very fundamental and glaring errors that were committed by the agencies. And I think the statutory duty that those agencies had to consider the economic impacts of their actions had the capacity and had the effect in these cases of improving the caliber of their decision-making, and were statutory requirements that the courts were amply able to apply effectively. So let me start with the first of these cases. It was a rule by the SEC that required that mutual funds have a chairman who was independent of the so-called advisor that really sets up the mutual fund. The advisor is a separate entity. The mutual fund has a board of directors, and the rule was that it could no longer be somebody with the advisor who chaired the board, had to be independent. Likewise, 75% of the directors also had to be independent of the advisor under this rule. This was the first SEC rulemaking that I got involved in, and the SEC has a statutory duty to consider the effects of its rules on efficiency, competition, and capital formation. Those are the statutory terms. I'd done OSHA rulemakings, I'd done wage hour rulemakings, so I got hired for this. I went and I looked at the record, and a couple things struck me. First, the cost-benefit analysis that the SEC had performed, despite its statutory mandate, took about 1 page in the Federal Register. It was paper thin, and the comments barely contained any cost-benefit analysis. Even though this was economic regulation on its terms, there was essentially no economic analysis. Even more remarkable, though, was the statement of the Republican chairman of the SEC when confronted with a single economic study that disputed his recommendation. He said, and this is a virtual quote, cast the study aside, he said, there are no empirical studies that are worth much. You can do whatever you want with the numbers, end quote. And more or less on that basis, he just refused even to consider the economic study. So we got this rule remanded to the SEC, and this case has been characterized as setting in a possibly high standard. Let me mention just a couple of the mistakes that the SEC made in this case. One was that one consequence of not having a management chair of the board of directors was that the independent chair was likely to have to hire staff. People involved in the mutual fund industry said these independent chairs, they've got other jobs. They're going to have to hire people to come in and help them do the work that's going to be required. That's going to impose costs on the funds, which can be passed on to the shareholders as a bad thing. The SEC, in adopting the rule, they said, first, yeah, we know those independent chairs, they're going to need staff, and we've made clear in our rule that they can hire that staff that they're going to need. But as to the cost, they said, hey, no, hold on now. We're not requiring them to hire staff, so you can't saddle us with those costs that they're going to incur if they choose to hire staff. I mean, utterly arbitrary and capricious, right? They were adopting a rule that the record showed was going to require the hiring of staff as a practical matter. But because it wasn't a term of the rule, they refused to consider the impact on the fund shareholders. A second thing that occurred in that rulemaking was that one of the SEC commissioners suggested that they consider instead simply requiring mutual funds to disclose whether or not they had an independent chair. If an independent chair leads to a better fund, investors will recognize that, they'll move their assets accordingly. Why don't we just do that? Seemed like a very sensible proposal, and the SEC altogether refused to consider it. That ended up being another basis on which this particular rule was invalidated. So what we're talking about here in one of these cases that's characterized as setting an impossibly high bar was some really elementary failings by the SEC as it purported to discharge its statutory duties. Now, a second case, and the case that Boyden mentioned it briefly, that's received the most attention, is the so-called Business Roundtable case, which challenged an SEC rule under which public companies would be required to turn over their own proxy to shareholders who wanted to put forward alternative candidates for the board of directors. As I think most of you know, ordinarily, if you're a dissident shareholder and want to put forward your own candidate, you need to solicit proxies for yourself, do your own mailings. This would have permitted free riding by certain large, in all circumstances really, institutional investors. They could put their own candidate on the company's proxy. And the SEC's theory in adopting this rule was this will lead to a lot more disputed elections. That will make board members behave better because they'll feel less secure in their seats. And it'll give shareholders more choice and enable them to elect better people too. So that was the theory for the rule. In justifying the rule and in doing the cost analysis, one thing the SEC said was, you got to understand, this mechanism that we're creating can't be used by just anybody. It's hard. It's hard to use. And so while commenters said there are going to be so many elections, it's going to be really costly, it's going to be against shareholders' interest, they said, no. Actually, they estimated there have been 68 traditional proxy contests over the last year or so. They said, our rule will only permit, will result in about 51 annually. So pause and consider that. They're saying the benefit of this new rule is it will make it easier to challenge elections. But when they're forced to do their cost-benefit analysis, they say, now this thing's going to be so hard to use. We're much better off with the current system, really. It's much better for shareholders. Utterly arbitrary and capricious. Worse yet, that was their cost discussion. They get around to discussing benefits. What do they say, buried in a footnote? They say one of the real benefits of this is the great frequency with which shareholders will be able to put forward their own alternate candidates. We estimate that 15% of American public companies will have disputed elections. Now, the DC Circuit characterized things like that as cherry-picking the evidence and contradicting the agency's own assertions in one place or another. It was absolutely right. And for the court to invalidate this rule on errors such as that was not to put a very high standard to the commission at all. The last case that I wanted to mention very briefly is a case, I see Rachel Brands here, that she and I worked on for the Chamber of Commerce and also for the American Petroleum Institute. It was a rule required by the Dodd-Frank Act under which oil companies were required to disclose the contracts and revenue agreements they had with countries and other levels of government where they had leases and exploration and extraction activities and the like. And the idea was you've got some countries that are receiving huge payments from oil companies, allegedly, and the leaders of those companies are keeping the revenues for themselves rather than letting them flow down to the people. If there's disclosure of what they're getting, then, I don't know, there'll be some sort of agitation within those countries that will cause the leaders to share the revenues. The industry stepped forward and said, this is going to be incredibly costly. It'll cost actually tens of billions of dollars because a lot of these countries prohibit those disclosures. We will have to stop doing business with them. And they said, it's just not clear what benefit at all is going to result from this, because those countries are going to go do business with somebody else that's not a US-listed company, and the disclosures are never going to happen anyway. And the SEC, it had now lost several cases on its cost-benefit analysis because it had been exaggerating the benefits and minimizing the cost. It had learned a lesson. So, in its final rule, it said the following. It said, the benefits here are very unclear. We're not sure there are any. We don't know what they are. This was required by statute. The costs, they are through the roof, tens of billions of dollars. And they called it a day, sat back, and considered this an effective cost-benefit analysis. The suit here contended in part, well, given how high the costs were and how minimal the benefits were, the SEC could have used its authority to exempt certain countries from the requirements of the rule. We found 4 countries where contracts in those countries alone would result in $12 billion in losses to U.S.-listed companies. We said, exempt those countries at least, from these requirements. They refused to consider that. They said, that's contrary to the spirit of the law. Judge Bates in the district court rejected that contention, as well as some of the other claims they'd made, saying that they did indeed have the discretion to fashion a less costly, less onerous rule. With that background, let me make some very quick observations about these cases and reserve further thoughts for the discussion. First, as has been mentioned, the SEC and also the CFTC, who's had a couple rules invalidated in part for deficient treatment of the effects of its regulation, are not subject to OIRA review. I think it's clear they would have benefited from OIRA review from an external party more closely scrutinizing their treatment of economic analysis. Second, contrary to what some commentators have suggested, as I've described some of the mistakes that were made to you, the court, the DC Circuit and the district court in the extractive industries case was not establishing an impossibly high bar for the agencies. It was asking for relatively basic tasks under that statutory mandate. Third, judicial review is possible. The errors that I've described to you were apparent to judges, really apparent to anybody who looked at the record carefully, and are the kinds of things that courts are qualified to pass on. And relatedly, the exposure of these kinds of mistakes plainly has the ability to improve the rulemaking process. The SEC put forward its proxy access rule on the claim that it would make it much easier to contest director elections, but then turned around and said, actually, this is going to be really, really hard to use. It should have examined that conflicting set of premises, and had it done so, it would have proceeded more effectively in the rulemaking. A final related point there is the ability that cost-benefit analysis has to constrain agency discretion. There's a dispute now about something called the Financial Stability Oversight Council, which has the authority to designate companies too big to fail. When you read its decisions, explaining its designation decisions, they are through and through ipsy-dixit in circumstances where it's plain they could have deployed what Michael described as generally accepted economic principles, and they just simply decline to do so. So cost-benefit analysis is certainly one tool available to constrain the agency's exercise of their discretion. Finally, in the realm of financial rulemaking particularly, to me, it's plain that while there are always challenges in cost-benefit analysis, there's no reason they are so great in the financial realm that cost-benefit analysis should be dispensed with. On the contrary, I would expect that in many respects it is easier for regulations in that area to be subjected to cost-benefit analysis than in areas where you are weighing not money on one hand against money on the other hand, but instead money against other types of costs or benefits. And in fact, financial regulation has as its premise that there are problems now in the financial system which will be enhanced by certain measures. And just as you must consider environmental effects when engaging in environmental regulation, it's plain that you must consider financial consequences through economic analysis when engaged in financial regulation. So I'll stop there and look forward to our discussion.
Thank you very much. Well, I look forward to the discussion too, and thank you to all the panelists for staying on time so that we actually have a little more than a half an hour for discussion. Before I actually have a lot of questions, and I'm sure people in the audience do. Before any of us have anything to say. Would any of you like to comment on anything each other said before we open questions up?
One comment about, intrigued, Michael, by your reference to the elder Scalia's statement that why do you want to, if you've just taken the White House, fool around with deference and those doctrines when now you want the deference to undo the deference of the preceding administration. And of course that's true as a general matter, but my experience with the Environmental Protection Agency, with all due respect to Richard, who never would be anybody's, just anybody's bureaucrat, that EPA is everybody's enemy, regardless of party. So.
Dick, you have a comment to that, a response to that one. All right, if we have questions, please come up to the mic and ask them. But while you do, I actually had several questions in advance, but this triggered so many more that I actually have different questions than I warned you that I might have. In fact, I'd love to know how people would respond to Michael's question about how responsive should agencies be to elections.
Well, we just mentioned that just now. Well, I think that's quite up to primarily to the President of the United States, and this Congress can do a lot to shape by holding hearings and making its views known and exercising its such review authorities it has, and along with whatever little budget nuggets it wants to drop into appropriations bills. But elections should make a difference. In 1980, it was fought not primarily, but certainly principally, over the scope of regulation. That was one of the central 2 or 3 issues over which the election revolved. We could see the same thing develop this time around. It's too early to tell, but we could see it. And Reagan won on the heels of marvelous anecdotes about ridiculous regulation, and he deserved the chance to do what he wanted to do, and he never encountered any major resistance from a Democratic Congress when he did what he did in the first term.
Yeah, I would add to that. I wouldn't suggest that the officials within the agencies themselves base their own decisions on election results. But I think it's imperative that they follow the leadership of the president and the White House staff. So in that respect, and I think that's Boyden's point, I think it's very important that the president lead and that regulatory agencies follow that lead. Now, some agencies by statute are independent. That's a separate debate that can be had. But even then, of course, it's important that the president be mindful of his own, or I'll stick with his own priorities in making appointments to those agencies. I will say I've wondered at times whether presidents may have made it harder on themselves to regulate or deregulate by taking as much as close ownership over regulations as they do now compared to, say, pre-Reagan. Reason being that the more it's plain that the president owns a regulation, the more blowback the president might risk if the regulation proves to be unpopular. So I think there's an argument under which centralization of rulemaking may make rulemaking slower and more difficult, even when its consequence would be deregulatory, which I think in some extent was then Professor Scalia point in the 1981 article. But you do see at times where the president is taking a very heavy hand with the regulation, and I've stepped back and wondered, would the president have more time getting this through if he weren't so firmly putting his imprimatur on it?
I would add to maybe an earlier point, whether EPA is everybody's enemy, okay? I'm thinking about that for a minute. And it seems to me, and I hesitate to say this in front of a bunch of lawyers, but it would be my sense that Congress has given EPA probably broader authority than in the case of environmental issues than it has in any other obvious example I can come up with, okay? And as a result, that gets EPA into a lot of different places that stir up problems. And so it may be true that it's everybody's enemy, but it's inherently so by the way it's been created. It would be my non-lawyerly observation.
So just to answer my own question and respond to Dick, I mean, so I'm going to defend EPA, if only very briefly. I mean, if you were to poll the American public, broadly, EPA is actually a fairly popular agency. The kinds of things that EPA does are actually pretty popular. But in terms of how responsive our agency should be to elections, one way I think of this in my lawyerly way is arbitrary and capricious review. What should the bounds of arbitrary and capricious review be when a new president comes to town? And then in the most important case, or the leading case in arbitrary and capricious review, State Farm, right? Then Chief Justice Rehnquist, in a concurring opinion, talks about this issue. Like, there's a new president, and new presidents ought to be able to implement their policies, but they should be constricted in some way. They should have to provide this is what I refer to as public regarding reasons. They can't just come into office and say, hey, we're paying people off, or the president feels like doing this. The agency has to be able to construct some set of reasons that connect the policy to a broader public purpose or to lawful authority. And so, that's, but I think it's an important question to keep asking.
Okay, thank you. All right, so when you ask your question, tell us who you are and please state it in the form of a question.
Of course. Lisette Garcia, FOIA Resource Center. Thank you so much for your remarks. I guess there's 2 points or questions. One, I work in the area of the Freedom of Information Act, and there's been a lot of judicial nullification to the extent that parts of the statute are not even enforced. So going back to your point about the bounds of arbitrary and capricious, what do we do when the court itself doesn't enforce the laws, when it comes before them and there isn't a nexus and all our hard look standard just goes out the window? I mean, where else do we go? And the second is, I'd like you to please address the new push by the administration to throw all regulation systems out the window, the public input process, in the name of more open government because it's collaborative and mutually iterative. This very week, the Administrative Conference of the United States published a paper explaining how, by non-lawyers, explaining how the regulatory process was actually too slow for the executive, and we should just throw it out and just, it just doesn't address the needs as fast as we need to. So there's a fast track idea. So if you could please, I'm thinking of U.S. Digital Service primarily and the 18F, and it comes out of the CFPB. I mean, that's how they operated. So thanks.
Thank you.
Well, if the courts are getting it wrong, you appeal or elect a new president. I think those are your answers. The second question, I'm just not familiar enough with at least the characterization of that ACUS statement to respond.
Yeah, I mean, one thing that should be noted is that ACUS is, a lot of independent agencies are actually quite responsive to the president, but ACUS is a pretty independent agency as these bodies go. And so, I'm not familiar with the report, but I wouldn't necessarily attribute the stuff that ACUS says to the White House. They might actually really disagree with the propositions.
I'll just add to that, and I don't know the report either, even though I'm a public member of ACUS, and
Me too.
I'm going to look at it now. But it also isn't even an ACUS recommendation until the full ACUS. So the reports themselves don't even reflect ACUS's perspective necessarily. But.
I mean, it follows on the president's comments that things will be and this
Huh. Okay.
Well, there are classic questions about how much process we want to have, right? And again, folks, will, from different political perspectives, will disagree with that question. It's hard to justify the current system. It's hard to justify any potential alternatives, really, because you could reduce the process, and then you're going to have problems with public. So you can increase the process, then nothing ever gets done. And so it's not clear that we're at the optimal. It's not clear what the optimal is.
Wayne Abernathy, American Bankers Association. I'm not a total skeptic when it comes to cost-benefit analysis, but it does seem to me that there's significant limits there. I was particularly closely involved with the '96 Act that broadened the requirements on the the SEC. But it seems the case that was won, it was because the SEC, it was like shooting fish in a barrel. They did such a lousy job of even trying to provide a lip service to the cost-benefit analysis. It seems to me that if an agency at least puts on a face of trying to do something that looks like cost-benefit analysis, the judgment is all really with them. The courts are going to tend to, I think, defer to their judgment of how they weigh the different things. I'm wondering if perhaps the real value in cost-benefit analysis requirements comes when you have the head of an agency or the president who really believes in it and wants to use cost-benefit analysis as a reform tool to say, well, there's a lot of stuff that I don't like that was done by this agency that I inherited, and they didn't do cost-benefit analysis. I'm going to use that analysis to justify the reforms that I want to put in place. Isn't that where the real strength comes in?
I'll give an initial response to that, and it may be that Boyden has some more thoughts about, the presidential role particularly. I think that in practice, what I've observed is that once the public, through their comments and potentially through litigation, brought to the attention of the SEC the errors that it was making in its cost-benefit analyses, that did force them to look more closely at things. The rules that were challenged, most of them were never adopted in any form, and I would say in part because in going back and taking a closer look, it became evident that they were indeed going to be challenging to sustain. I want to comment briefly about participation in rulemaking. It's just critical. What these kinds of statutory requirements can do and what comments can do is force agencies to grapple with hard questions and to explain themselves. And the more they can be challenged to justify what's being done and to explain it, either the more cogent they will become, or, as I think happened in some of these cases, the more it will become evident the emperor wears no clothes, subjecting them to vulnerability in court. So I think that the rulemaking process in that sense works well. It works especially well when the public participates in a very thoughtful way, because as I tell my clients in rulemaking, it's often garbage in, garbage out. If you don't participate in that process effectively, then the quality of the rule deteriorates. With respect to the question about presidential leadership, no doubt that a president who cares greatly about not burdening the economy with unduly costly regulations is somebody who's going to move the needle considerably in improving the quality of regulations, and I do think that would have a greater effect than the threat of litigation in the absence of that kind of leadership.
Just to add that, many of the financial agencies and high-tech agencies are so-called independent agencies. They weren't such a large part of the economy back in 1980, but they really are now. And having them be independent is really an anachronism, and it should be changed. And look at Obama and the FCC; he didn't treat it as an independent agency, and there is no actual legal constitutional reason for doing so anyway. Nevertheless, the SEC doesn't even have a for-cause limit on firing. The SEC was founded in between the two basic cases, Humphrey's executor, and when the SEC was formed, it was illegal to constitute an independent agency. But people forget that, so it just becomes sort of habit that the SEC is independent, and that's kind of bizarre. But there it is. Don't forget that in addition to that part of electing a new president is you get new staffing, and it really is important who you staff. And just to add one point, EPA, I think, has no doubt the broadest delegation of any agency except maybe the Fed. But by the same token, it has the fewest political appointees, I think, per square bureaucrat. And it's really a struggle, and every White House has struggled with it. Every Democratic White House, except maybe the current one, has struggled with it along with Republican. And when they arm EPA bureaucrats to go marauding around, that doesn't make them very popular. And when they go,
There's a fair amount of variation that some of it may be related to party, to be sure, but frankly, some of it is just related to individuals. I mean, some individual agency leaders and some presidents who surround themselves with, people like Boyden, who are very strong-willed and interested in these issues and knowledgeable. It's sort of quixotic. I mean, I could think of EPA administrators who, some of whom, are just really interested in cost-benefit analysis and economic analysis. And of course, in part, they're responding to the White House. There's no question about that. But I could think of others, even within the same administration, same presidential administration, who are they're just ignorant about it or not really interested and don't pay much attention to it. So there's a personal element here that I think, individual element, really, that you can't leave out of the conversation.
Okay, we have 2 microphones, so I'm going to go to the back microphone and then back up to Paul.
Well, thank you. I'll address my question to the moderator because I know you're kind of a generalist and have been looking across different elements of different industries. My family owns a small securities broker dealer, and every year I'll comment on 1 or 2 rules coming either from the SEC or from FINRA. Now, most of my comments are on one issue, which is disproportionate impact on small business. And actually, we've had a very good track record. There are a lot of exemptions and alternatives for small business in financial regulation for securities. But I've learned from reading a particular SEC release I'm interested in about something called the Regulatory Flexibility Act, in which the agencies are supposed to focus on this issue as a matter of law. It does seem rather a bit toothless, and the definitions are a bit strange. The SEC did a hand-waving analysis on this thing, Consolidated Order Trail, that I'm interested in. Have you ever seen that legislation used to any good effect?
Yes. So the Regulatory Flexibility Act does require agencies to look at disproportionate effects on small entities. And there is an office, the Small Business Office of Advocacy, whose job it is to defend that and work to enforce it. So yes and no. So sometimes agencies just do a boilerplate, and agencies themselves, the agency head can designate whether or determine whether their regulation has an impact or not. And sometimes they'll make that determination, and the Small Business Office of Advocacy says, that's not true, but it's the agency, under the Act, it's the agency that makes that determination. I'm going to defer to the lawyers, though, about whether there's been litigation that's been successful on that. So BRIFA did make it, did allow courts to review that.
Yeah, there's been successful litigation applying those requirements. My clients tend not to be small, so I'm not. I don't read those cases very carefully, but certainly they exist.
We can talk afterwards. I have people I can connect you with. Paul.
Yeah, thanks, Susan. An excellent panel. Paul Kamenar, and speaking of ACUS, I'm a senior fellow of ACUS, and I want to ask a ACUS question to Gene. You and I were on the same committee talking about judicial review of agency rules. I was just curious with respect to your SEC case on mutual fund. You mentioned the point that the SEC did not consider the option of whether funds can voluntarily disclose that they have an independent chair on the mutual fund committee. My question to you is, was that something that was raised at the rulemaking level or just in the judicial review in the courts? And if not, could it have been raised at the judicial review level?
It had been raised at the commission level. In fact, one of the commissioners said, I have a better idea, why don't we do this? And my recollection is that that commissioner's colleagues ignored him. As to the question whether it could properly have been raised in the first instance at the court level, my view would be that that alternative is sufficiently obvious and I think arguably preferable that it ought to be legitimate to raise it at the court level, even if it had not been raised below. But that's a disputed issue, and Paul was referring to an AICUS recommendation that was debated a couple of weeks ago on that topic, not specific to that case, but more generally.
Hi, Rob Hartshorn with the Madison Coalition. Just as the states forced Congress to propose a Bill of Rights, what are your thoughts on the Regulation Freedom Amendment, which is backed by 500 state legislators, 3 governors, the American Farm Bureau, Mr. Gray, and the General Counsel of the RNC, which would require that Congress approve major new federal regulations? Thank you.
It's a proposed constitutional amendment. That's just the question. That's what we're talking about.
Yeah, is it a constitutional amendment?
Well, if Boyden likes it, it must be good.
So
It's like a codification of the Reins Act, that's what it is.
the Reins Act, yes. Okay. So this morning, the majority leader mentioned the Congressional Review Act, and this would change the default of that. The Congressional Review Act is regulation goes into effect unless Congress votes to overturn it, and this would say Congress would need to vote to approve it, otherwise it doesn't go into effect.
So, without getting too much in the substance of Reins, one of the observations I always kind of thought was interesting about this debate about kind of the idea that agencies should propose to Congress for approval regulations rather than propose regulations. That's kind of how Europe works. That's kind of how the European Parliament works. You have the Commission, the European kind of regulatory agencies. The European regulatory agencies then propose to the European Parliament regulations, and then it kind of goes through an up or down vote. There's an amendment process. But I just think it's kind of interesting politically that many of the folks that kind of like these kind of constitutional or these kind of ideas like Reins or this constitutional amendment, I would normally think of the same types of people that want to Europeanize the American constitutional system. So.
Yeah, we talked about this briefly as we prepared for this panel, and I haven't studied this concept in detail and read all the pros and cons on it, but the basic concept is that Congress has now delegated vast discretion and authority to the agencies. And what if we reverse that a bit by saying, fine, the agencies in the first instance can deploy all their vaunted expertise to determine what the best thing is. But before it actually becomes law, let's make Congress come back into the picture and take an up or down vote, of course, subject to presidential veto as well. In that way, we get the input of agency expertise, which we're told is so valuable and that Congress lacks. But on the other hand, we don't have Congress delegating so much of what it's supposed to be doing to agencies. That's the concept. I think it's a really important concept. One argument would be, well, Congress is so dysfunctional that it would never be able to act as these regulations came to it. To me, that, in a sense, is sort of giving up on democracy. And my hope would be that Congress would, when forced to, find a way to become functional again and to take up and deal with these major regulatory questions rather than having them handled by agencies in the courts.
George Pullen, I'm here as a citizen. I'm not representing anybody. My question stems closely from the previous one. When we talk about mechanism for policy, it seems like BCA being more robust broadly is supported, but when we then get into the mechanisms underneath and we look at these independent agencies and others who are set up under a premise not weighted like this panel. We have a weighting here of 3-2 for fairly even economists to lawyers, but the majority of these agencies have very, very small offices of analysts and economists. And so we're talking about, and I'm curious to each of your opinions because, again, we have a good mix, your opinions on how we'd have to change the construction of these agencies to technocratic versus bureaucratic agencies so that you actually have a breadth of expertise so that you can have 10 economists in a room with 10,000 opinions to then come to the best middle answer versus many agencies now that might have 1 or 2 BCA personnel if they're lucky. Thank you.
Well, one quick thought on that, and I'd love to know what Jean thinks, but the SEC has a huge staff of economists, and they're really quite accomplished economists, too, so I'm not sure that that's their constraint. I know when I was overseeing regulations, the Department of Homeland Security had, they were doing an abysmal job of trying to do benefit cost analysis, and they had very few staff who could handle it. And I think they've tried to beef that up.
I mean, Markopoulos in his book, No One Would Listen, talks about the Bernie Madoff debacle, obviously, but one of the things he points out is that you don't have applied economists performing the work of the enforcement review, and so if we now extend this to a more broader view of BCA needing to be more robust, and again, applied economists doing that work, they're definitely lacking according to his accounts anyway. So.
The SEC has hired a large number of economists. I think Susan's right. They did not have that kind of staffing at the outset of this series of cases that I've described, but they have increased their staffing. It's not going to work, though, if the economists are not integrated into the actual decision-making process, too. If the way an agency is using its economic staff is simply to justify decisions already made, that's not the purpose, and that's not going to immunize an ill-considered regulation from judicial challenge.
I would second that, second Gene's point. Back in the mid-'90s, I did a count of the number of economists at EPA, or early '90s, and it was remarkably small. I mean, literally, I don't know, I'm not going to say the number, but it was really small. And the agency, in fact, has hired a lot of economists since, okay? And probably the number of, if you just count, the quantity of economists has probably tripled, I'll bet, since in the last 20 years. But unless they're given the authority, as Gene says, and the mandate, it's really not going to achieve it. So it's kind of a necessary but not sufficient condition to have greater influence for economics.
Yeah, and just to kind of add another agency to the mix is OIRA. OIRA's staffing is something that you have to worry about over time, and the number of economists, the qualifications of the economists at OIRA. So if you have really beefed up agencies that have substantial economics departments, and then you have a kind of thinned out OIRA with some economists, some public, folks with public policy backgrounds, you can create an imbalance where OIRA is not in a great position to actually do the kind of needed substantive review of what the agencies are up to. So you need to have sufficient number of economists integrated into the actual decision making, but you got to make sure that's counterbalanced with oversight as well.
Susan, do you know how many employees OIRA has now, say, compared to when we were in the early '80s?
I don't, actually. I just asked for that information. I think it's about 55, and I think in the early 80s it was 100 or more than 100. So it has changed a lot. And that 55 includes, as Michael said, a lot of non-economists. We have just, I think, 4 minutes left, and I'm going to ask one question. I'll tell you my question. You can tell me whether yours is better. How about that?
Sounds
so
fair.
My question as moderator is whether, since this is the congressional, the focus of this whole conference is congressional oversight, is should Congress have a body that is able to, like an OIRA, that is able to oversee agencies?
That is actually an idea I have supported in things I have written, so we are in the same foxhole on that one. I'm Kevin Kosar of the R Street Institute, just a couple blocks away, and actually this kind of ties into your question, which is some of the people I've talked to on the Hill have been saying, well, regulatory look-back is not working as it should, and we may need to make it more robust. But then I've also heard the criticism of, well, regulatory look-back's never going to work because methodologically, agencies can just methodology shop and pick the methodology that they want to get the results and be able to say, hey, this validates our regulatory result. So maybe we do need a CRO, right? Go ahead.
Yeah, so those do tie in together. Does Congress need one, and would it help with the retrospective review?
I would agree with, I think so. I think the CBO should do it, and I'm not even sure the CBO shouldn't do on really high cost legislation coming out of Congress, a prospective regulatory impact analysis on that legislation. I mean, we knew Dodd-Frank was going to be a big deal. It should have, and Obamacare was going to be a big deal. They both could have benefited from a cost-benefit review by the CBO.
Yeah, I mean, again, just to draw the European comparison again, that Europe has an impact assessment board. They actually do cost-benefit analysis of regulation, of not just regulations, but because all regulations are also legislation. So they look at legislation as well. I wouldn't personally put it in CBO just because I think CBO is good at what CBO does, and regulatory cost-benefit analysis is very, very different from budget impact analysis. But just increasing Congress's analytic capacity to, participate in these discussions seems like a no-brainer, seems like a very good idea.
So I think the idea of independent review is important. On retrospective analysis, as I think a number of us have said, you really need to have an independent party. You can't have the administration do it, no matter which administration. So that's a no-brainer. It's also true that in Europe, like I haven't been overly impressed with the quality of the either the initial cost-benefit analysis or any oversight that's taken place in Europe. So I kind of wouldn't jump at that model. And I think it's hard for, I also should say, disclosure, my first job in Washington was at CBO, okay? And CBO kind of struggles in many ways to sort of make an impact on different issues. And this would be a very different role for CBO, certainly if you did it prospectively. It would really it would just be complicated for them, and their staffing, a lot of things would have to change. And I just think it would need some thinking. Retrospectively, it's also complicated for them, but probably a little more doable.
And I haven't given this a lot of thought, but what about requiring that at least certain rules sunset? And for the rule to remain in effect after that, there needs to be an evaluation of how effective it was, and that readoption of the rule would then be subject to judicial review. That would be another way of coming at it. And based on the remarks I made, I do have faith in the capacity of judicial review to at least frequently, if not always when necessary, frequently to call out and result in the invalidation of flawed rules.
Well, join me in thanking the panel. I think this is very came in too late to hear all the things.